Hello, good morning, good afternoon, good evening from wherever you join us today. Thank you so much for joining. Today we are discussing the report and the topic in general of who polices the police. I would like to thank and introduce our speakers for today. We have Ian Scott, former director of Special Investigations Unit in Ontario, one of investigative agencies that investigates police. We have Vamaita Kimani, Director of Systemic Reform at the International Justice Mission in Kenya. Pedro Abramove, the director of the Latin America program at the Open Society Foundations, based in Brazil. And Yuri Bilausov, who is the head of a department that investigates and prosecutes violations of human rights of citizens in the office of the Prosecutor General of Ukraine. I'm Masha Lisitsina. I work at the Accountability Division of the Open Society Justice Initiative. And together with Ian, I also co-authored the report that we are discussing today, Who Polices the Police. Neither the topic is new, nor the problems in our society of the excessive use of violence of police, or just use of violence of police, not just use of restricted force when necessary. And often doing so in impunity are also not new. What we see changing is that violence that we always knew takes place behind closed doors. I work on the problems of torture for over 25 years. And we almost like axiomatic, we almost always say torture is a crime that takes place behind closed doors, and it's only the victim and the abuser who know about it. This is changing. In countries that are proudly saying that they're democracies, like Chile, Brazil, United States, police uses violence more and more on the streets. And this violence is captured by citizens' videos. Is becoming a part of public discussion. It's not anymore hidden as it often were. And what we still need to see that we need to call some of this violence what it is. It's crimes. They're alleged crimes, they're potential crimes, not always. Again, the police or other state agents sometimes are allowed to use force, but it has to be strictly monitored. It has to be strictly necessary. It has to have a lot of controls. And we are often afraid to speak that these are just alleged crimes. And the recent verdict in George Floyd case in the United States remind us that yes, sometimes we have a criminal justice response to this problem. That's what the report and discussion today is about. It's about criminal investigation of violence by police and other state agents around the world. The report, Who Polices the Police, looked at 15 such independent agencies and prosecutorial departments in Africa, in South America, in the Caribbean, in Eastern and Western Europe, in North America. And what we see is that, of course, it's not a cure-all. Just creating an agency and saying, or just even investigating the police is not enough. We need to change the way how police works. We need to change the culture. We need to improve the internal controls, but it's also very important to investigate. And hopefully the report and the book and experiences that we saw shows that it's possible. It's possible even in the countries with widespread violence. It's possible in common law. It's possible in civil law. We see some example of changes. We couldn't assess effectiveness of each party. But for example, in the COM, in Jamaica, the Commission for Investigation, in 2014 put out a report where they analyzed the fatalities, the deaths when police conducts planned operations. And the question was like, how do you work? You plan this. Why are people killed and in such numbers? The fatalities decreased from 33-37% in these years to 12%. They still exist. The report and this work is on this intersection of what we say political and technical. You can create the best agency in the world. But if there's no political decision that in our society we want to seek accountability, when those whom we gave powers to protect us abuse this power, there will be laws that will say, it's just like immunity of police from prosecution or anything else. You just will not be able to investigate. On the other hand, we are not speaking of just societal reproach. We are not just speaking that we need statements from high-level officials that this behavior is not allowed. We are talking about possibly convicting somebody in criminal trial on the highest possible standard of proof, like what is here beyond reasonable doubt or any other. You cannot put people in jail on political decision. You will be just doing the same as was done to the other side. So we need to also look at the technical side of this investigative bodies, of their competence, of the access to forensics, and all other nitty-gritty aspects that we don't like to think about. But they're also necessary if we want more justice for victims, if we want fair trial, fair procedure for police, and if we want to change our societies for better overall. On that, I'll stop here and I'll give the floor to Ian Scott, to the co-author of the report Who Polices the Police, for the introduction of the report itself.
Thank you, Masha, and thanks for having me. As Masha indicated, I'm the co-author of the report with her, and as she indicated, we explore the efforts of about 15 independent investigative agencies and prosecutorial departments in South and North America, Africa, and Eastern and Western Europe that conduct criminal investigations of police involvement in death, serious injury, torture, sexual assault, and enforced disappearances. We make a series of recommendations clustered into 10 areas of preferred practices based upon our experience, research, and interviews with experts in the field. The paper reviews the essential elements needed for an effective investigation and prosecution of state agents who allegedly commit serious crimes against the very people they are sworn to protect. In our view, an effective independent investigative agency needs to be independent, with the authority to conduct thorough investigations and accountable to the public. So dealing with independence first, the paper outlines the legislative framework required to guarantee the independence of an agency of this nature and its director and its authority over specific subject matters, typically death, serious injury, and allegations of sexual assault. And in terms of the agents, typically it's police officers, correctional officers, and in some societies, a military, which uses its military against its own citizens. The what the agency investigates and the who it investigates need to be well defined so the state agency knows that it will be the independent agency that will be conducting the investigation. Second, with respect to thorough investigations, the recommendations and the paper also address the qualifications, powers, and training of the new agency's investigators, emphasizing the importance of immediate notification of incidents falling within its jurisdiction, and defining the IIA, or Independent Investigative Agency's role as the lead investigator. Several sections provide details of the essential elements of effective investigation, including securing the scene, segregation of involved state agents, their duty to cooperate with the IIA investigators, post-incident notes and interviews with officers, physical evidence, post-mortem autopsies, and unique issues when the investigation focused on those who disappeared after last seen in detention. And then on the accountability issue, our research found there was a risk of a government setting up an independent investigative agency, looking good on paper, and then just not performing particularly effectively. To address that issue, we recommend that all incidents in which the independent investigative agency conducts an investigation report its decision to the public. In cases where there's no criminal charges laid, the report could be a summary of the findings of the investigation, along with some reasoning as to why no charges were laid. It could be as simple as, quote, the investigation revealed the deceased who was shot by the subject police officer was pointing a firearm at another officer, unquote. If charges are laid, the public accountability mechanism will shift to the court system, where we hope the jurisdiction in question supports the open court principle and permits the public and the media to be present during all court proceedings. Finally, on this point, we recommend the IIA publish an annual report summarizing the year's activities, discussing some of its cases, and including trends reflected in its case numbers, as Masha indicated that the Jamaican Indicom does with respect to the reduction of fatal police shootings in planned operations. Now, as we've indicated, I'm the co-author of the report. Masha and I work closely together on the interviewing and researching of the IIAs, and what I hope I brought to the paper was my experience as the director of Ontario's Special Investigations Unit for 5 years. The unit is called the Special Investigations Unit, or the SIU. In my research and experience, it is literally the grandfather of these independent criminal investigative agencies. It's been around for now 31 years, with its sole mandate being criminal investigations of on-duty police incidents, of death, serious injury, and allegations of sexual assault. It started in 1990 when a number of social forces came together, most notably a larger multicultural population in Toronto, Canada, which is Canada's largest city, a more reformist provincial government after the province had been ruled by one party for 37 years, and controversial police shootings of young black males in the Greater Toronto Area. The government of the day set up the SIU, as I indicated, in 1990. And when I was a director, which was between 2008 and 2013, we were conducting roughly 300 cases a year, investigations. Many were screened out at the beginning because they didn't fit well into the mandate, but there were thorough investigations in approximately half to two-thirds of those cases, with approximately 10 criminal charges laid a year. It is now such an integral part of our society that I don't think any government of any stripe could repeal the SIU, the legislation governing the SIU. However, for its first 10 years of existence, from 1990 to 2000, there was immense pressure by policing agencies to undermine its effectiveness. The statutory changes leading to the birth of the SIU were very bare bones, giving the police a lot of room to argue they did not have to cooperate. It was underfunded, and the investigations were attacked as incompetent when cases went to trial. This led the government, after about 8 or 9 years of basically kind of chaos, to significantly increasing the funding because of the pressure of community groups was such that it could not disband the SIU. As well, the government passed a series of regulations that set out the rules of engagement between the IIA investigators and the police on issues such as immediate notification, freezing the incident scene, the SIU being the lead investigative agency, and the duty of officers to cooperate with the SIU, particularly in the area of post-incident notes and statements. These changes helped a lot and brought a certain degree of peace between the SIU and the police. While there are still many issues to address to make the unit more effective, I took those experiences with the SIU through our writings in the paper, and many of them are reflected in our recommendations. So briefly, in terms of what I learned from our research and interviews with people throughout the world, and we're going to be hearing from a couple of them momentarily, there are many different issues. Clearly, there are many different issues. There are many different statutory issues, and many relate to the difference between the civil law jurisdictions and the common law jurisdictions. For example, in common law countries do not permit victims and NGO participation in the prosecutorial process to anywhere near the same degree as the civil litigation systems, the civil law jurisdictions. In Argentina, for example, and Pedro may be able to speak to this point, the complainants can actually have their own lawyers and present their own witnesses in court proceedings. This is unheard of in common law jurisdictions. And countries have different relationships between the police and their prosecution services, which are reflected in the way the independent investigative agencies operate. For example, in Ontario, the police lay criminal charges without the consent of the prosecutor or the prosecution service. And that protocol is reflected in the SIU. I, as a director, laid the charges. Then they went to the prosecution service. But I've come to understand that in many other jurisdictions, the investigative agencies are much more subordinate to the prosecution service. Also, some IAs are tasked to investigate historical events, unlike the SIU. The police ombudsman of Northern Ireland looks into allegations of security violence related to the Troubles, going back to the 70s, now about 50 years ago. And the Ukraine's Department of Combating Ill Treatment, as well, perhaps we'll hear from Yuri, is investigating incidents, I think they still are, related to the Euromaidan protests. Another major difference in some countries is that the independent agencies investigate their own military, as I indicated beforehand. This is unheard of in Canada, where our military falls under federal jurisdiction. But in Jamaica, for example, the INDECOM, or the Independent Commission of Investigation, has jurisdiction over the country's military because it is used on a regular basis against its own citizens. Again, unlike the experience of many other countries. So finally, what we hope that we have done in the paper is discuss the preferred practices of many jurisdictions to promote concepts of independence, thoroughness of investigation, and public confidence in police oversight, as well as respect their legal traditions. Through effective criminal investigations of these serious injuries involving state agents, we hope each jurisdiction will make state agents subject to their rule of law. So I'm happy to wait while we move on to hear from the other witnesses, but I turn the matters over to Masha.
Thank you so much, Ian. We'll save the questions to you, to the panel discussion. I would like to turn now to also other speakers, to Vamartha Kimani. And I would like also, before giving you the floor, Vamartha, I would like to acknowledge that you work at the organization where your colleague, Willie Kimani, was killed right after representing a victim in the investigation against the police 5 years ago, I believe, close today. It's one of the cases, together with Judge Patricia Ascioli in Rio de Janeiro, that we mention in the report. These are not jokes. Even these investigations sometimes cost lives. And we would like to remember Willie and many others. Vamartha, Independent Policing Oversight Authority in Kenya is quite new. And this was born, and I'm thinking of like Colombia today, out of the massive violations of post-election violence in Kenya. Born more or less, as we understand, out of the report of Commission of Inquiry. And while IPO is not in the Constitution as part of this whole constitutional overhaul, what changed? You work a lot with victims. You represent victims. You work with IPO. What's different today than it was in investigations of police violence, in your interactions with the police and with the victims, than it was when it was before IPO was established?
Yeah. Thank you, Masha. Thank you, Ian. First, let me just acknowledge what a fantastic job you both did on the report. It summarizes succinctly everything anyone who would want to be learning or understanding the work of independent investigative agencies would need to look at. So thank you for capturing that, and also the diverse experiences from different countries. Thank you as well for remembering and acknowledging my colleagues. As you have said, 5 years to this week, it is the 23rd of June, my colleague on a routine work duty coming back from court with our client, together with the taxi driver, were abducted and disappeared for 8 days before we recovered their bodies. We'll be commemorating that this year as we reflect on delayed justice and what it takes away from families and victims as we wait for justice. And anyone can follow us in the discussions that we shall have through this week at International Justice Mission Kenya on delayed justice. Now to your question, before and after, what has changed in investigations? What do we see? So IJM in Kenya has been around since about 2002 and was working to represent cases of police accountability and cases of child sexual assault. And with the police accountability cases, and your report acknowledges this, that most of the people who experience what would be excesses from the police, serious injury or deaths, are also in many instances subjects of investigations of a criminal offense, because there's always that space in between. Was this person a thief and it was a routine arrest and it was lawful use of force, or was it torture within detention and cells? Is it an arrest and a follow-up or a cover-up? So we spent a huge chunk of the first 8 years representing people who are in the criminal justice system as a result of police excesses. But coming closer to, close to 2010, we were seeing investigations, and I think one of the lessons I would take away from the time before IPOA's existence is the heavy ability to cover up instances of police excesses, because the investigator is still within the agency that is the police, and is very easily able to cover up what it is that they have seen or what they know. And the easiest way to cover up while still appearing to be conducting a lawful criminal process is an inquest. And more often the cases would be moved into public inquiries. And the public inquest is not a conducive environment for any form of accountability. First, it does not result in criminal convictions, because what the court is doing in a public inquest is reporting on the report of a police officer, calling to the public within that jurisdiction. Does anyone know anything that could have happened here? Could you come and give us information on what happened here? So it's essentially a whodunit incident. And depending on who's coming and what they're sharing, you could be getting truth or you could be getting more reinforcing cover-up information. That's not an ideal situation for the victims, because it's public, because anyone, including officers, can be listening in on what is happening and can use the information gathered to intimidate, to coerce, to derail that particular inquiry process. And so what we would see that was said to be a means of accountability was a system that would actually not deliver accountability, that would not deliver protection for victims. What has changed since coming in of IPOA? There has been significant changes. First, the clarity on who is investigating what. And I know the report talks about this and starts to break it down. Who is investigating what? There is now clarity that IPOA is in place and is investigating these serious offenses and police misconduct, and there's a classification of what that amounts to. Of course, there remains the disparity between police do investigate serious crime, and so if this incident that is done by a police officer is still crime, it still falls into the purview of the police. But that's the gap in between the two of them. So there's clarity on what they're investigating. There's clarity on who is being investigated, particularly defining law enforcement, the kind of action that can happen. There is clarity on how to treat victims. There is clarity both in statute and in other complementing statutes, for instance, the Witness Protection Act, that gives clarification of what to do with the most vulnerable of the witnesses, allowing for IPOA to transfer witnesses who are vulnerable into witness protection and other agencies. And then also to what Ian was talking about, the role of the victim in the criminal justice process. We now have the Victim Protection Act. So we also have legitimate rights protected for victims, and they're able to there's a more recognition of the place of victims within this particular criminal justice system, both their right to information, their right to participate in the criminal proceedings as themselves or through their representative.
Thank you so much, Vametha. Pedro, let me turn to you with an easy question. I would like to ask you to look more in the political context and at the whole continent, if you could. How political context either impedes investigations or enables them? How can it change? We speak about guarantees of independence for such bodies, and many countries we speak about in Latin America again have the democratic structure of government, have independent institutions. But what do you see? What do you see today on how politics affect what these agencies can do and how we can investigate the police in Latin America and Caribbean.
Thank you, Masha, for inviting me for this panel, and congratulations to you and Ian for the wonderful job with the report. I think not only it's very solid and easy to read, but also I think it's very useful with very recent data for a debate that I think needs the refreshment, right? And I think you touch in different points that are not obvious that I think help a lot the debate. So thank you very much for this report. I think your question is excellent, and it is exactly, I think, a point that in general we don't talk about when we talk about rule of law and human rights litigation, which is the political environment and context that many times, unfortunately, is more important than the international treaties or the institutions on paper that we have, and that I think many of us lawyers try to focus more on what is written than on the political context, and that's part of our failures. I think in the region, particularly in Latin America, there is a political context, not only, and I'm not only saying about the authoritarian governments of Bolsonaro or Maduro or Ortega, right? But there is a political context that relates law and order and law and order speech and relates citizen security as part of an authoritarian approach, right? And even in democratic governments, we saw that many times. And there is a trap on this because there is, of course, we are in the region that is responsible for a third of the homicides in the world, right? So there is a public pressure for citizen security to be effective. But it is not about effectiveness, right? It is much more about the answer to the fear that people feels because they are in the continent that is responsible for the most of the homicides in the world. And that's very dangerous because that response to the fear many times is just a political response and not a solution. We are not concerned about reducing the homicide rates. They are much more concerned about what is the political response to my fear. And sometimes the political response to the fear is more police killings, right? And that fits exactly in a police that goes on war, right? That is not there to provide citizen security as a right to the citizens, but it goes on war because people are afraid. And that, in a political sense, calms people, right? It shouldn't, but it does, right? So it is in that context that we are seeing independent investigations agencies work, right? With the pressure from the public that they cannot be in the way of police doing their work, right? Doing their job. And that's how many of those entities see. That's how many of those prosecutors' offices are pressured from the public to, again, put the criminals in jail and not to stop the police from doing their work. And if you don't understand that context and you will only look on paper on the advancements that legislations got, you won't understand why in Rio, for example, you'll have 1,500 police killings in 1 year and almost none investigation, even with some institution that on paper could look fine, right? Because there is so much political pressure around it. And I think a lot of what expresses, and I think there is one important point that is raised in the report, which is the cultural aspect, right? If you just bring to those agencies the same culture that is the police culture, and people who are being evaluated with the same methods that has, that includes having a hard police, the militarization, law and order approach as the main thing, and you put those people into those investigations agencies, they will try, they will see their role there as a role to protect the police, right? And then the role of civil society to make those organizations accountable, I think, is really important. One example that is not one that you've analyzed, but it's very important for us in the region is Mexico and what happens with the 43 students, right, in Ayotzinapa, in which the police was clearly involved, right? And it was only through independent and then really independent civil society investigation that we could find the real involvement of the police that was completely blocked by the institutions that were supposed to investigate. And I think there is one other layer that is important for us, and for me to complete this answer, but for us to look, which is the connection between the police and organized crime. Right? So there is part of the police in Colombia, in Brazil, in Mexico, in Jamaica a little less, which I think it's a very interesting example that you bring, but there is part of the police that is so entrenched into organized crime and so captured by organized crime, right, that they use the excuse of the law and order spirit, the militarization, and the non-accountability, right, that they ask because they are in war. They use that not to protect mano dura approach or a militarization approach, but to protect their involvement with criminal organizations in which part of those killings are related to. So part of the killings of the police in Latin America are not related to a police brutality that is just the police being hard on crime, too hard, even going beyond and above the law. It is part of the organized crime logic. They are killing people because they want those people, they want the other criminal organization to advance in that particular area. And then they use the protection they get from an inefficient independent investigation agency to protect their involvement with criminal organizations. So the political context that put pressures on those investigations not to stop the police job at the end is strengthening organized crime and strengthening the involvement of organized crime with the police. And I think the lessons we take from this is if the police is above the law, the police will join the criminals, right? If the police cannot be accountable to those mechanisms, you open at least the possibility for, and you a free way for the police to be involved with criminal organizations. And we see that in many countries in Latin America, right? So there is, I think it's that understanding that political context and trying to understand the logics that go behind that beyond what is in paper. I think it's mandatory for those who want to really make those investigative independent agencies really efficient and really accountable to the Constitution and the international norms about human rights.
Thank you so much, Pedro. I'm sure there will be a lot of thoughts of other panelists on similar issues. Let me thank you for kind words about the report for all of you. And I should acknowledge David Berry, our editor, who made the report readable for you. We did have our editor, otherwise it would be much harder to read. Let me turn to Yuri. Yuri, thank you for joining us. You are the head of a new department in the Prosecutor General Office in Ukraine. Your department started being operational just in November 2019, if I remember correctly. Tell us how it is on the inside, what you can. What do you need? What do you need to be successful? What preconditions you already have that you hope to be successful, and we know that you already have some advances? And what are the challenges, whether cultural or structural, that just make your work difficult?
Thank you, Masha, for your question. It's a great pleasure for me to be with all of you guys. And it's a very difficult but interesting question because for 4 years I was a head of NPM in Ukraine, and now we also always were facing a situation when we discovered cases of torture and we sent papers to prosecution, and there was no effective investigation. And it was a really big problem for Ukraine, and even the European Court for Human Rights stated a pilot decision in 2012 in Kavirzin case, saying that, come on guys, you need to establish a mechanism for effective investigation. And since 2012, just for the last couple of years, we see some movement in this respect. What was the problem for my personal perception? First, there was no institutions responsible for investigating torture. So someone should be responsible. If it's not a full time for someone, it means that it would be part time for someone. So if investigation torture is a part time, if you should investigate other types of crimes, it means that torture would be something you don't spend much time for that. And as soon as the new institutions appeared, first investigators in 2018, and then specialized prosecution office I'm representing, we see that there was some movement because, again, what I was trying to also mention and thanks again for the report, the series, because everyone mentioned that. I have to mention it too. This report is really good. It's like something that we could use to assess our situation in Ukraine. I mentioned that just investigators is not enough. If we have effective investigators who gather evidences on torture, if prosecutors don't understand that, they will block any investigation. They will not take evidences. They will not go to the court to blame police because of different other reasons. It means that as we have specialized prosecution, we see that investigator and prosecutor together could really work effectively. What is really challenging thing, it's a forensic, because in torture cases, as you know, forensic expertise is one of the most needed and instrument and evidence. And we have really good qualified forensic, but the level of state support and material conditions is so not so good, and it takes 4-6 months, sometimes 6 months for one expertise to analyze both the injuries. It really takes time for us to speed up the investigation. The problem is also the judiciary should be very operational. It shouldn't take 2-3 years in the court to get a verdict in such cases. If it's not operational, it means that the victims, they don't see pretty effective results. They lose the hope that the perpetrator would be punished, and that's the question, not just to judiciary, sure, but to prosecutors and victims. Another challenging thing is a victim support, victim and witnesses support, because they are facing the huge pressure from law enforcement. It's not just ordinary criminal; it's a criminal who is a law enforcement officer. It means that his or her ability to influence the victim or witnesses is several times more higher, and definitely victims should have a support. In Ukraine, we don't have a special procedure for support of victims of torture. We have a legislation to protect witnesses and victims of ordinary crimes, and we use it, but definitely we would need, and we work on that, to have a specialized procedure. People should know where to apply if they became a victim or witness of torture. They definitely should know, because a lot of them do not know about that. If they were a witness of torture or victim of torture from law enforcement, pretty often they call police, and it's not exactly the right agency to do, because that should be independent, as we have State Investigation Bureau or Prosecution Office should be first who would receive such kind of call. And we work on that too. I should admit that together with the NGO activists, with Renaissance Foundation, with Ministry of Justice, we drafted the strategy for combating torture in Ukraine for the next 3 years, and hope the government would adopt it in next months. And this strategy and action plan so suggests very concrete steps already mentioned, and also the mechanism of whistleblowers. We really work on that, because we believe that in 2-3 years we would get the more information from inside the system, that police officers, penitentiary officers who would be a witness of torture, they would inform us. Fortunately, we already have pretty good cases, which is very good signal for us that some officers already do not tolerate torture, and they already started to inform us. But they are not. There is no, as I said, there is no special mechanism for protection of whistleblowers in cases of torture. And right now we study the mechanism for whistleblowers in corruption cases, because in Ukraine we already have this mechanism. It just started to work, and we analyze it, and we believe that there would be some need to change the legislation. effective cooperation between all state institutions involved in investigation of torture. As I said, it's a State Investigation Bureau, Prosecution Office. They really have to have this common idea what they're doing. It's better if they have common criteria of assessment of their effectiveness, because unfortunately we still have pretty old statistical system of assessment when the investigator has been assessed by number of cases sent to the court. And if sometimes if he or she are investigating not just torture, but plus minor crimes, they sure for them it's easier to send 10 minor crimes to court than to spend 1-2 years working on the torture case. This system of effectiveness criteria should be definitely changed for police investigators. A very effective thing is, which is pretty new for us, because we usually the prosecutor and investigator together, they take lawyers representing the victim as like not just enemy, but lawyer and prosecutor pretty often in a court, they represent different sides. And that's why they are not ready to work together. But we have several cases where we have effective cooperation with lawyers representing victims. And it's really, really show us what's the potential of such a cooperation, because victim doesn't trust prosecutor, victim doesn't trust investigator, at least from the first days when they start to cooperate. But victim trust has a much higher trust to lawyer who could come. It's like an additional role, like a psychologist for a lawyer who establishes the first contact, who can explain the victim the criminal procedure, how it works. Just a couple of days ago, we had a meeting with a lawyer, and she said, victims, they usually think that in a week or maybe maximum in 2 months, the perpetrator would be punished. And because they don't just understand the criminal procedure, as soon as it doesn't happen, they started to lose the hope that it's possible to get the remedy or whatever. And in Ukraine, we don't have up to now the system for rehabilitation of victims of torture, and that's another challenging thing. Just no one works with victims of torture, and there is no system, no provision in the law, nothing like that. And we already have a system pretty good and pretty effective, which could be taken as the example for us. It's a system for to support victims of domestic violence. And in Ukraine, there is a law. In Ukraine, there is a system of institutions which already work with victims of domestic violence. And we study this system right now, and we believe that definitely there would be need to establish such kind of system. Protection of victim, as I said, it's a huge problem, especially if victim is in a places of detention, if it's a police isolator, or if it's a pretrial detention center, or if it's a prison, and the victim became or suspected to be, or informed us that he became a victim of torture. It definitely need to huge or fast removal from this penitentiary institution to another one, and it also takes time right now, and we work on that too, because people just don't want to inform. If even there is information from NGOs that someone was tortured in penitentiary institutions, even if investigators go there, if they don't remove the person from that institution to another one, the victim will never tell them, because as they usually say, you would leave us here, you would go home, but we would stay here, and they would, after you visit, they would torture us again. So that's a lot of challenges that we face right now. We try also to work in the sphere of implementation Istanbul Protocol standards in Ukraine, and together with the Ministry of Health, Renaissance Foundation, and some of our colleagues from NGOs, we designed like forms for medical practitioners, forms for fixation of body injuries, which would be very easy and convenient, and suppose also pretty fast notification of law enforcement, specialized law enforcement, if the person comes to hospital, for example, with body injuries and says, I was tortured by law enforcement. And the doctor should fill a specialized form and notify State Investigation Bureau or Prosecution Office. And we work on that. We already designed such kind of forms, together with forensic doctors. And now we are in negotiations with the Ministry of Health. They would integrate such forms in e-health systems they are trying to introduce shortly. It's much very brief, maybe, for trying to ask to you pretty complicated questions. I would be ready to answer any questions if there would be. Thanks again.
Thank you so much, Yuri. And I think we are moving to a discussion with everybody. And also, I would like to invite the audience, those who were kind to join us today, please post your questions in the chat, and we'll be happy to add the questions from the floor as well to the discussion. To start, let me take a question from what Yuri was speaking about. How do you win public confidence? This is again, a lot of these agencies operate in just an adverse environment overall. The legislation often gives a lot of powers to the police. And some of the actions that would be clearly a crime if it just happened on the street from a common person to a common person, might end up being ruled legal, right? We know that not all, even when you create the agency, right? Not a lot of cases will result in convictions. And the rates might differ, but we know that, again, it's not a panacea. And also, we do want fair consideration. We want a fair examination. So what can you do to win public trust? How do you interact with the public, with the victims? Let me turn to Wamaita first to try to answer this question, to share the experiences from Kenya.
Thank you, Masha. And as I answer your question, allow me to add to something Yuri said. And I like, as a prosecutor, he was the one who said a good investigation is not enough. The prosecutor matters. And one of the things we've also learned, and comes from statistics here, and even if you look at the results from the work of IPID in South Africa, is that the prosecutor's tool is also legislation. If you haven't articulated the offenses properly, then it becomes very difficult to get convictions for these kind of things. The discharge of a firearm is not an offense, but a complaint on the discharge of a firearm then amounts to, depending on the context, an issue of an attempted murder or an assault leading to grievous harm. And at that point, the standard of investigation and prosecution is the same for a crime. However, the circumstances around police action should be uniquely assessed, so that if you can identify that this was the incident, then you would be verifying what aggravates it to be a police excess that should suffice in terms of evidence, as opposed to putting the bar in the criminal, prosecution standard, which is a lot more difficult, because this is not just civilian action. It is someone who's trained for the carrying of a firearm, the use of a firearm, and so discharging it is not treated as just an ordinary discharge. So I just wanted to add that to what Yuri was talking about, because I think sometimes the tools they are given, the tools the investigative agency has, the facts amount to an offense, but then you don't have the right charges that you would be wanting to prefer in court to deliver you your successes. So how do you get public confidence? I think, to my mind, a couple of things need to happen. The responsiveness of the institution. When incidences happen, does the public have the view that they're responsive, that they're able to come, they're able to properly investigate, they have the necessary resources to investigate, they have the necessary capabilities, equipment, not challenges of movement, not challenges of technology. That, I think, just already puts off public and victims. The engagement that the institution has with victims at the point of interaction, because that's who will go and tell the rest of the community how that agency works. So if the victim and the witnesses go back and say, those guys look like they know what they're doing, or they're really, courageous, they're interested in resolving this case, because the word that will come from the people who interact with the agency becomes gospel truth. There's not going to be any research behind it. If a victim comes and says they are not interested in solving my case, it doesn't matter how many times the investigative agency says we have an interest in solving the case. You have already lost that person's trust. You are not legitimate in their eyes, and so it becomes very difficult to actually resolve any cases, because they also stop participating in your process. They won't avail themselves as witnesses. They will not be fully honest as witnesses, and you've seen many instances of this. People will give just enough truth because they no longer trust the investigative agency. So the kind of interaction that you have. And perhaps a very difficult thing to quantify, I would say, is courage. And this perhaps is also drawn from who is in the institution. Do they look like they have the guts for the kind of work they have been given? If the institution does not look like they could come against the very scary force that they're supposed to be going against, then you don't get the public's trust. You don't earn that if you don't look like you're courageous enough, or you're coming out and you're articulating yourself in a manner that would inspire that confidence. That people would say, they don't say this institution, IAIA, is going to do the work. They name the people. They say so and so is interested in justice. And so you cannot get away from who the personalities in the institution are, whether it's the overall institutional heads, whether it's the investigators that interact with the victims and the witnesses on an everyday basis. That demonstration of their courage to actually do the work is very critical in building the confidence of the public. And then finally, results. At the end of the day, they could go through many an investigation. You need a conviction. And first you need your first conviction, then you need the right convictions. If I think it was APCOF that did a study of the investigative agency IPID in South Africa. And when you disaggregate their study in terms of statistics, there's deaths in police custody and then deaths by police action. And the incidences of deaths by police action are about 13% of the overall cases, about 1,300 over the period of time they have been around. And out of these cases, deaths by police action, it's the category of cases that speak to non-law enforcement engagement. So intimate partner violence, domestic violence, done by a police officer, not necessarily as law enforcement. Those get 56% in terms of convictions. So the majority of the cases that are delivering convictions are not necessarily what the wider public would be thinking is being resolved, which is the contact of police during their policing, when they're wearing their policing hat. And so the results of those investigative agencies are very critical. What the results mean, where are we getting convictions, where are we not getting convictions, also matter to delivering the public trust.
Thank you, Amaisa. Ian, I know this question is very important to you. Would you like to offer a few comments from your practice?
Well, the previous comments are all extremely relevant and very well considered. And there's many issues involved here. But the one I would like to focus on right now is the relationship between the investigative agency and the prosecution service. Because what we saw, and when Mitha brought up South Africa, what we saw there was they actually had a very wide remit. They did a lot of investigations, their investigative agency. But they did the reports, and their reports seemed to disappear into the ether and miasma of the prosecution department. There was, and at the end of the day, it was very hard to find anybody who was really accountable for the decision-making process. And it's one of the reasons why we make a recommendation, and I appreciate we're dealing with different legal traditions and protocol, but one of the recommendations we make in the report is that there be a particular individual or a particular office who is responsible for making the decision. My personal experience at the SIU was that laying charges was actually one of the easier things I did. I used to be the head of a prosecution service of the police. And then, I used to do these prosecutions. And there's a whole other world out there that we can talk about. But laying the charge meant that I'd done my job. And to some degree, the public can say, look, a charge has been laid, and then it's really up to the prosecution service. The more difficult issues, and this is going to be the vast majority of these investigations, just a reality of looking at the police use of force, because we as a society permit the police to use force. It's much more nuanced than an individual using force. So where's a really difficult issue in terms of public confidence? In my view, it's a reporting of a particular individual or a particular office back to the public in the cases where there's no charges laid and there's been an investigation. And it's one of the reasons why at the risk of sounding a little, shall I say, Canadian centric on this point, I recommended that there be a director who makes that decision. I had to live with my decisions, and they were very hard to make because some of them were very controversial, much more controversial, frankly, than laying charges. It goes into the prosecution service. It can take years. And Jamaica has a very good system with intercom, but their prosecution service is problematic. It can take 8, 9, 10 years to get a verdict in the Jamaican system. And you do see that atrophying of interest and public confidence in that process. So there's kind of a seamless relationship here between an agency that can respond quickly, as Omitha has indicated, be it with the public visibility, appearing to do a very competent job, hopefully doing a competent job, into the decision-making process, and then from the decision-making process, either the public perhaps not having confidence in the decision. I mean, I made decisions that I was attacked for, and rightly so. You're not going to have a social consensus on many of these issues. All I thought, I did my job if I was convinced the investigation was thorough and I could provide legal reasoning to justify where, in my view, it ought not to go to trial. So, it can be debated in a public forum, but that's what really I think a healthy criminal justice system is all about. Not necessarily people agreeing with everything, but understanding the process to arrive at the decision making. I concur with your views, I'll wrap up here, that there has to be cases with enough gravitas and strength that some of them have to lead to convictions. Otherwise, it's viewed as a paper tiger.
Thank you, Ian. We start getting questions. Again, we invite everybody in the audience. If you have any questions, more broad to our speakers, please post them in the chat. I'll turn to them in a minute. Pedro, I would like to give you a chance to also comment a little bit on the building confidence in this type of institutions. But also, if it's appropriate, what do you do in Colombia today, right? The president of Colombia made the statement that he's open to the police reform. We see violence that was pretty unheard of for the capital, at least, for the capital city. What do you do today? How you take the situation like that forward?
Sure. Thank you, Mash. I think, the Colombian case, and I think even looking to the Chilean case, just before, I think are two cases of, huge police brutality in something that is not against crime, right? It is against democracy, right? Against people protesting in the streets, and of course, this is part of our history, but we need to connect those, right? So we need to understand that in Colombia, the police is under the Ministry of Defense, and it is under the Ministry of Defense because the police has been, and for years, particularly the U.S., but international community in general, were supporting the Colombian government to build a war structure. Part of it because there was a civil war in the country, but part of it because they've connected the civil war to the war on drugs. And they brought the police into as a part of the war process, right? And so we have a police that is trained in Colombia to be one of the state arms against inside the war, right? And against enemies, right? And again, inside the Ministry of Defense. And so we can't have a police responsible for regular patrol or for doing police work against criminality or reducing violence, or even to patrolling protests that can go violent in any place in the world, and you have techniques to control democratic protests all around the world. But if you take a police that was built to fight the enemy, right, that is under the Ministry of Defense, that was built to fight a war against rebel groups and the war on drugs, right, with a lot of money, with equipment, and to do that, when they face the challenge of dealing with democratic protests, they will go. They will do what they are used to do, right? And that's that, we saw the violence, the brutal violence from the police in this case against young people that were going in the streets to demonstrate, right? And to demonstrate against the president. So even if the president gave some statements condemning the police violence, the police was there to defend the president's government, right? And the president's position. The demonstrations were demonstrations against the president. So it creates conflictual messaging. And I think in this case, I don't see that the Colombian police has today the mechanism to, with all those brutal violence being so politicized, with a president that were clearly against the peace process, right? And I think has the war message as a strong one again. That if the current institutions in Colombia have the authority, the legitimacy, and the political interest, I think, to investigate the police brutality in this case. So, for example, international participation, an ad hoc commission, right, that could really investigate and understand what happened, but also that could propose a police reform, right, from what we are learning from this, that will have elections in Colombia in April. It is fundamental that whoever wins those elections in Colombia can propose a police reform that will rethink Colombian police, not in the terms of war, neither the war on drugs or the war against internal groups, but to think about citizen security in the country, right, with the Constitution as the main guide for its policy. And I think that it is one example for me that if we don't look again into the legitimacy of the agencies, how they were built and all that, we won't be able to address the issue. I think the Colombian case is one that I think it's important for everyone in Colombia right now to read this report and understand the challenges and how we want to build a renewed police for Colombia in the next year.
Thank you, Pedro. We started getting the questions. Again, I invite more questions. If there is any, please don't be shy. I'll try to address them myself and to all our speakers. Of course, feel free to react to each other. It's not easy in online forum to guess who wants to react. Yuri, I'll address this question to you, and also then maybe Ian, you would also have thoughts on this. In many countries, the audiovisual equipment became very popular in police stations, or also I assume body-worn cameras as well. How do you assess how important is this equipment, and what are your comments about the police dodging, right, with video cameras that often they don't see the recording, it happens to be off and so on? How important are they in your practical investigations, and if you have any recommendations? We'll go to Yuri first, and again, feel free to speak of other questions as well.
Thank you, Masha. So video is extremely important as evidence because it's better to see than to hear many times. Yeah, better to see once the situation. And that's why for the last 5 years, we are actively helping police to establish the custody record system in Ukrainian police. We really help them because the idea is that the person, as soon as the person be physically arrested, still the whole process of being under the control of police, the person should be under the video surveillance. And police supports this idea. The head of national police even declared that the custody record system would be the system, their priority. And they even designed together with several NGOs and again with Renaissance Foundation as our main partner here in Ukraine. So we designed the task when the process of fixation starts from the body camera. When the patrol police arrest someone, now in Ukraine, they're obliged to use body cameras. The idea is that sometimes it happens, especially in torture cases, when then it's switched off or it doesn't work. Sometimes they have this problem, but not very often, fortunately. And then when they fix the physical arrest, the transportation of the person to the police station also should be under the video surveillance because they have video cameras in police cars. And then when the person been taken to the police, they custody officer who would ask the questions how the person been arrested, and sometimes even download the video from the body camera and keep it in the database. And this system is already piloting in several detention centers, in police detention centers. But as we all understand, so the biggest number of violations takes place during the first hours when the police arrest on the street and takes to the police station, not to detention center, which is the next step. And that's why we are piloting on a couple of police stations. But it's really difficult problem and process. It's a lot of challenges because police started to understand that they have to show their procedures, to videotape it, and it's for guys who didn't get used to work according to the law. It's the biggest problem because all practices related to violence, to the pressure, to the videotape. Sure, no one wants it to be documented, as they say, but with the help of such videos, the recording system, if it be covering the whole police stations, the officers who didn't want to use according to the law, they would leave police. I believe in that strongly. In addition, we are working hard, we didn't mention that, but we are working hard in introducing investigative interviewing in police. First, we started from anti-corruption institutions because they were more ready to adopt new practices of conducting interview. Police is just on the way, because the problem we faced also, it's not just about the punishment of police. Sure, if guys did something wrong, extremely wrong, if it's not excessive use of force during arrest, sometimes we see how we need to analyze situation. But if you take about the torture cases or like rape cases or electroshock or whatever, it's definitely torture, and these guys definitely needed to be punished seriously. But it's also a question of training them. No one really trained them how to effectively get the information from the suspect without using the violence, because sometimes, but often, they use or they perceive the violence as an instrument, because the person is quiet. What should I do? Yeah, he or she doesn't tell me the information. What should I do? Sure, we tried with the help of punishment from our side. We tried to push them to legal instruments, saying, guys, if the person is quiet, maybe you should, because we investigate torture. We don't torture our suspects. Our suspects are police officers. And we say, guys, come on, do you see that we didn't torture any of you? But we send the case to the court, and it's okay. It means that we can do it, using other instruments. And it's actually a good example for them. They can't ask us, oh, but you don't know how to investigate it. We know, we do the same. And our suspects are police officers who are trained guys. But we managed to gather, who destroy evidences, who delete videos, who try to remove the blood. So they know how to remove evidences. And that's why, they really need to be trained. They need to be trained how to effectively do their work. Another problem, so it's not just about the video, but it's also related question. As I said, the assessment of police. That's huge pressure. You need to send like 5 cases to the court a month. You need to, if you don't send 5, it's just maybe 3, 4 a month. It means that in some time for them, they really don't care whether the suspect is guilty or not. They need to send the case to the court. And torture or violence helps them to speed up the process. The person confesses, give them the information, ready, next one. It's like, in the factory, they produce cars or whatever. They produce these criminal cases. And we tried also to change the situation, saying, guys, you shouldn't speed up. And that's another, the main question for me, the trust of the public. The state institutions, they lost this connection with the public because they're being assessed not by the trust of the public. Some of them, they don't care. Why should I? Why should I think whether the public trusts me or not? I'm not being paid by public. I'm assessed by my boss in the capital. If we don't change the situation, if police will not be assessed by the public, at least partly, because otherwise we won't change this the way they do. And finalizing this video is extremely important. And definitely, we had another case actually. We had another case when the video.
I think we'll need to move to the next speaker.
Okay,
sorry.
Okay, yeah.
Sorry, I thought we had a lot of time. Ian, I'll give you a chance for a brief response on the videos from a very different reality. of Canada. And we have a few more questions, and I would like to give everybody a chance to say a couple of final words.
Well, okay, very, very briefly, the biggest change in the use of force for confessions in Ontario was a decision by our Ontario Court of Appeal that says, look, if you want to have a confession ruled voluntary and admissible in court, this is about the mid-'80s, it has to be videotaped. There's a reverse presumption. If it's not videotaped, you've got to climb up a big hill to prove voluntariness. And that, now, it didn't solve all the problems, and there's a lot of ways around it, but it certainly solved a lot of the issues involving confessions in Toronto that were garnered by the use of force. Yeah, I mean, my personal view is that body-worn cameras are a gimme, but it's funny, when you look at the really major changes in the area of video, they're not the body-worn cameras, they're the citizen cameras. You can go back as into the 90s in the US with the Rodney King case, which is really the beginning of the use of video and the use of police accountability in a major way. That was a citizen video. I mean, it was an old clunky camera. He just happened to be out on his balcony trying it. And then we look at the recent George Floyd case. I mean, that was another example of citizen video. The trouble with citizen video, and I certainly used it when I was at the SIU, or institutional CCTV video, is it's too episodic. It may work, it may not, but there's absolutely no doubt that it's valuable. These are difficult cases to reconstruct in a courtroom. We break down into very, classic sort of criminal cases. What is a criminal trial? You're trying to reconstruct an historical event. And obviously using audio video will be of great assistance, particularly in these cases, because forensics is often very ambiguous. Injuries or fatality of post-mortem report can often have a lot of nuance around it if the perpetrator is permitted to use force. So and confessions don't work all that well either, because you're not going to see too many police confessions in this business. So some of the classic criminal tools to solve investigations are not really available to you in the same way. So yes, I endorse everything you said.
Thank you, Ian. For a second, abusing the role of moderator, working on more litigating torture. The only one case in Kyrgyzstan, where I am originally from, where video was important and where police was so sure of their impunity that they brought absolutely beaten person to a bank to collect money that his family was forced to wire as a bribe for the police to not kill him. And the bank video was the only one that worked. But they were so sure that, and the bank teller was not giving anything to this person. And that's where the trial commenced, because nothing else, they worked on all other evidence. We have a question that I think would be specifically for Pedro, but also a more general one that Vamaisa probably will ask you to reflect on as well. One is about abuses by security officials, by the military. And in the report, we speak of them when they fulfill police functions, right? In the report, we do not go into military overseas. It's also important, but a little bit different. Probably a set of questions. Do you think that independent agencies should investigate such violations? Do you know any examples? Do you have hopes? Pedro, I'll address it to you. And Pedro, also, there was a question, how do you start an investigative independent agency in Brazil, given that prosecutors are only ones that can make accusations, that can lay charges, and in the current political situation, you will not get a new bill approved in Congress. Pedro, will turn to you, and then Mamaisa to you on the security question as well.
Sure. On the first question, on the militarization, I think the premise is we've been against, and I think only time has shown we were right, that we shouldn't have military in any way involved in policing, right, and citizen security. And one of the elements is because we don't have the mechanism to prosecute military that follows the same rules that we should have to prosecute police. So you ask them to perform police role, to be on the streets, to deal with citizens and not enemies, and then all the rules that they are that they have to be accountable to are rules that were thought for a war situation, right? And of course there are nuances, but if you take it and you see it in the end, that's the way it works. And I think the damage that involved military into citizen security in Latin America has been immense, right? And it's I think that's part of it. I could speak only about it for a while, but I think that's a part that I think we've seen, that the lack of accountability is one that shows it's one more reason to not have military involved. In terms of the question, I think there is many ways in which we can look at it. We can have, and we have had in many cases, independent organizations that had the ability not to prosecute criminally, but to prosecute, to have administrative punishment to police, that could fire the police, that have many that were independent, that were inside, even inside and reported to the governor, for example, that worked really well, that had non-policemen and non-prosecutors leading those organizations. We have very good examples of it. It is different and I agree, for the criminal prosecution. And then we need to have prosecutors, of course. But then what we do have is the example in Rio that I think was stated here, that was dismantled this year, when you can create a special body inside the prosecutor's office to investigate the police. That is independent from the police, because the prosecutors in Brazil, public ministry, right, in Brazil is one of the most independent in the world in terms of structure. But what happened is, I think, first of all, although the prosecutor can be very independent, they are not independent from the public pressure and the political pressure that I was referring in the beginning, that ask the prosecutors to be the ones who are fighting crime, that don't stop the police and all that. And that's the key element, right? How we can make them independent from that, and not from the governor itself or the police itself, but from that public pressure. And I think having both, so an independent agency that can put forward the cases, even if they can't prosecute criminally the cases, and then a specialized agency inside the prosecutor's office that can do it, I think it's the best way for in cases like the Brazilian, that to counterbalance all the pressures to avoid investigations and to avoid accountability that we have.
Thank you, Pedro. Vamete, if you have two thoughts. Security services, military. You are muted? You are muted.
I was just jumping in. Thank you for that. So saying I'll get into the military question. And I'll start with, have there been examples? The report actually refers to one of the incidences, I believe, in South Africa, the Collins Kosa case, that was quite popular in the enforcement of COVID regulations. And the military was out on the streets, and there was an incident of brutality, and military did not find any liability for the military officers, but the police who were standing there, through the investigation of the independent agency, were recommended for disciplinary action for inaction because of being present when the incident happened and not intervening. So what happens when you have military in operations? And I think in the Kenyan context, we have not just military, but we have disciplined services that also have jurisdiction in certain areas. We have those who protect the forests. We have those who are disciplined services for wildlife protection. And those areas have human contact, and there's excesses that also happen there. I do believe whenever an agency is enforcing policing powers, they need to be under the oversight of the agency that oversights police. Because at that point, you are not the institution that you ordinarily are, but you're exercising policing powers. So policing powers are kept under the control of an organization or an agency established for purposes of addressing that, oversighting that. And there would be two ways of doing this. There's oversighting of operations, because you do have instances, and that's what has happened, even we've seen with the global pandemic, where you have the call for support from other agencies who come out and are supporting and are running an operation. So having the independent agency being able to oversight how the operation is run, advising on this is more also a professional to make sure these are run professionally. Then also catching any incidences that amount to criminal conduct. Because the scope of criminality, and I come to your second question, Masha, on discipline, and I'll speak to one thing, discipline or criminal prosecution. Ultimately, the purpose of oversighting the work of the police is to reduce the culture of criminal conduct in their engagement with the public. You cannot do that merely by criminal prosecutions and convictions. There is a cultural component, organizational culture that is changed by what happens in administrative action. What happens at the lower tier level, the things that will say to people, this conduct is not going to be appreciated within my institution, not just externally, because the other one is a more external, more public rejection of their conduct. But the one where the institution is saying, even we who do the work that you do are saying to you, this is unacceptable. We do not want to be associated with this conduct. That's a very, very powerful place of changing the culture of the whole institution, because you cannot manage to investigate and prosecute and secure convictions for a whole entity. And if you have a really widespread nature of excesses within a policing institution, then it is best to be also working on the culture change internal, even as you deal with accountability for the serious crimes and the serious offenses.
Thank you, Vamaisa. And we see it a lot also. I think in South Africa, it came out so strongly that our interlocutors were saying, now police, when citizens try to complain, say, just go to independent agency, right? And that's why also we discuss a lot, the jurisdiction also needs to be very, very clear. You cannot just now throw all the responsibility to independent agency as well. We have the last questions that we'll be able to address, and then I would like to give a minute each for the final thoughts. Ian, I'll turn it to you. It's a question from Trinidad and Tobago, one of the countries that they cover in the report.
Yes.
And there, the independent agency, as you know, makes a recommendation to Department of Public Prosecutors. But then it's the only country with this situation. The DPP returns the case for the police for charges that start to conduct their own investigation. The question is, how can we speed up this process? But I think you might have more general comments for this statement.
Well, that structure, in my view, is highly problematic. It really defeats the whole purpose of having an independent investigation. I mean, theoretically, the way it should work is I appreciate. I think Trinidad and Tobago has a relatively new agency. They should be the ones doing the thorough initial investigation, and there ought not to be input from the policing services. I think perhaps one of the problems might be they're simply relying upon the traditional model, which is the police always lay the charges. And to some degree, you have to break out of that paradigm and say, look, if we're going to do independent investigations, we're going to permit this independent agency to make the decision as to whether there's going to be a criminal charge. And so I guess at the end of the day, with the greatest respect to Trinidad and Tobago, which it's good they're taking steps forward, and there are a number of issues that have to be addressed there, but you don't want to undermine your own institutions. And once again, it gets down to some degree, this relationship between this new, in that case, independent investigative agency and the prosecutorial service. In a better world, and I think it's a preferred practice that we talk about the paper, is you want to make sure that somebody's responsible for this decision. You don't want the independent agency to say, well, we did whatever we could, we gave it to the prosecutors. Prosecutors say, well, we did whatever we could, we gave it to the police. And then it kind of disappears into oblivion, or the police say, we have a different view. And then it's all so, jelly-like that you can't get a focus on exactly how this investigation took place. So with the greatest respect, I would suggest they reconsider the model.
Thank you, Ian. We had time. Thank you so much for all our speakers. I would like to give you a chance for 2 sentences each, much 3, if you would like to say any final messages. And Yuri, we'll start with you.
Will
Yuri,
not be the last. I really believe that such kind of meetings and such kind of reports, it's the first but not the last one. It's really huge need for such a mechanism in different countries to talk to each other, to share the information, to share best practices. And I believe that we will be able together to do that. For me personally, it's really, really important event and report. Thank you so much.
Thank you, Yuri. Pedro, we'll go to you.
Thanks, Masha. And I agree with Yuri that I think that the richness of this report is exactly the nuances, right? It's not trying to have one model, like although we do have recommendations, but it's, recommendations are lessons from the concrete experiences in very different realities. And I think what we can learn from failures and successes in different places is what will make us move forward. And I think this is, if we can, try to have people involved in those investigations in different countries to read those nuances that appear in the report, I think we'll have a lot of progress from it. So again, thank you very much from the report and congratulations.
Thank you, Pedro. Mamaita.
I'll just follow in the steps of my fellow panelists. I mean, I agree with Yuri and Pedro. It's a necessary report, and just to latch on what Pedro was saying at the end, gives necessary nuances for people who are in those agencies. Just reading the section that was on who are the investigators, the disassociation of the independent institutions investigators from state agents is an issue that is at play here now in determining whether you can hire former police officers into the independent investigative agency, yet also realizing the person who has the wide breadth of experience in investigation is someone who was a state agent. So being able to have that in a report, I think, gives an assurance to these agencies that it is not yet, perfectly established what works, but as the team, Ian and Masha, you have given promising practices. You have given an indication that this has some promise if you follow this direction, or you can consider it. So thank you so much for this. It opens up a place for conversation, and we look forward to what else builds out of this particular report.
So much, Mamaita. In your final few sentences.
Well, very briefly, thank you for all your comments. And Mamaita, you actually hit it on the head. The report talks about preferred or promising practices. We don't lay down any edicts. There's obviously, it has to be adjustable and adaptable to the legal traditions of that country. But at the end of the day, I think that the watchwords in these sort of agencies are its independence, the thoroughness of the investigation, and the ability to report back to the public through a public accounting system. So thank you very much.
Thanks so much for everybody. And I would like to also acknowledge that this report was the effort, of course, it's published by Open Society Justice Initiative, but it was a lot supported and in discussions with Latin America program, with Eurasia program, the Open Society Institute in Eastern Africa. We now also work with our Western Africa foundations and Ukraine and Georgia, and so many colleagues shared their expertise and supported this effort. It truly wouldn't be possible. We don't have time, but I've made so many mistakes trying to write things. Like I made up some criminal codes for Argentina, for provinces, and somebody was like, we don't have any. So you read badly in Spanish. It truly was only possible because of generosity of all our interlocutors who are all mentioned in the report. I see some of you that you joined us today. Thank you so much. We hope it's a useful tool, and we hope to continue this conversation. And huge thanks again for everybody to making time.